Yes. Thank you so much for joining in, sir. I'll just give a brief introduction to the session today, and so
Is it
that
okay
our
if I
audience
introduce
knows.
myself?
Sure, sir. Sure.
Okay.
Please go ahead.
My name is SK Murthy. The total experience that I have, including engineering and IP, is around 28 years, and IP is 20 years. I work for Intel, but today I am not speaking on behalf of anybody other than myself. So whatever I speak are my personal views. It does not necessarily represent the views of my employer or whosoever it is. Let's get into the session, right? Yeah. Okay, thank you so much. Sorry to interrupt you and take over, right? The title says, um, why do we need SEPs for, or what does FRAND mean for Indian companies? Uh, my my initial thought is FRAND, whether it is an Indian company or a multinational company or an individual or anybody, right? It is, the principles are the same, and if we don't have enough standard essential patents in our armor, then I'm I'm thinking myself, or I'm putting myself in the shoes of an Indian company and talking about it, right? If we don't have enough standard essential patents, then the first impact would be you don't have a negotiating power with the SEP holder, and that is true for every other field. It is not just for SEP holders, right? I mean SEP. It is not just true for SEPs. If you don't have enough standard essential patents in your portfolio, then it is your, to start with itself, right? You're not on the same level playing field for the negotiation. So that is the first impact that a company would have, irrespective of whether it is a multinational company or an Indian company or anybody. If they don't have patents, if they don't have standard essential patents to start with, they don't have a level playing field to talk to or to negotiate with standard essential patent holders, right? That is the first thing. And what is the consequence of that? If you don't have a level playing field, what is the consequence of that? You could end up paying higher royalty, right? You could end up getting lesser number of patents. You could end up getting licensed to lesser number of patents. Paying higher royalty, there was a research study a couple of years back, and it said if the implementer of the SCP, if this SCP implementer also had a patent portfolio, then the average payout of royalties to SCPs would be around 8% or so, right? In the absence of any SCP at all, right? In the absence of any SCP at all, the implementer, the standard essential implementer, would end up paying up to 25%, right? Which simply means that if a device is costing 100 rupees, right? Just to give you an example, even though I don't subscribe to royalties at the royalties calculated at the end product level, just to give you an example, if I am a company and if I don't have SCPs, right, I end up paying 25 rupees as the royalty. But if I have some SCP portfolio, I'll end up paying 8 rupees as a royalty, right? Just to put it in perspective with a very simple and crude example, that's how it would look like. And after stating all this, after stating this, I don't have to emphasize, because it is so very straightforward, that it is very important for organizations to develop standard essential patents, or to develop technologies and inventions which can be covered by standard essential patents. And then um, even though, of course, everybody cannot develop everything, everybody cannot do everything on their own. In spite of having good portfolios, good standard essential patent portfolios, they would still have to get some license. All I am saying is, uh, when you get into that game, when you get into that negotiation, you will have a level playing field, right? It does not mean that, okay, if you have a patent portfolio, you can hand twist or arm twist the SCP holder. I am not saying that, or I am not subscribing that. All I am saying is, you can go and talk confidently, right? It is just like this. If I am educated, if I have good knowledge, if I attend an interview, I can talk well, right? It is as simple as that. So in an interview, having knowledge, having educational background, having skills is a chip that you use, right? Is the currency that you use. In case of a SCP negotiation, having SCPs and willing to negotiate fairly is a currency that you have. So you are that much more confident. So from that perspective, irrespective of whether it is an Indian company or a multinational company or academics, you should definitely strive to have patent portfolios. You should definitely be innovative and protect those innovations through inventions and innovations through and all the flavors of intellectual property rights that I have. With that as a background, right? With that as a background, let me start. And today, whatever I talk would be very basics. And if we want to get into actual practices, court cases, probably we might need one more session some other time, right? For sure. Okay. Here is what happens. Even before we get into FRAND is probably a little far away. We have to give me 5 to 10 minutes before I actually get to FRAND. Even before that, we need to look at standard settings organizations. What is a standard? What is standard settings organizations? And how does the standard settings organizations operate? And by the inherent nature of standard settings organizations, what are the issues that might come up and what are the advantages that might come up? So I would like to talk about it, dedicate some time to talk about it. Are you okay with that? Or if you already know all this, then probably we can directly go to FRAND as well. Any thoughts?
Please elaborate, Dr. Mukta.
Okay. So as we know, standard settings organization, especially in the telecom domain, I'm focusing more on the telecom domain. It is the major advantage of having standard settings organization in the telecom domain is interoperability, right? Interoperability simply means different handsets, different makers, different carriers. They have a common language to talk, right? They have a common language to talk. If they don't have a common language to talk, then I should be fixed, or I should be hooked with one particular carrier, one particular handset manufacturer, and I can talk to customers who only have that. All these things are very, very restrictive, right? So standards is a common language based on which all these operators, handset manufacturers, technology providers, chipset manufacturers, they can all talk the same language, so that irrespective of whichever device you put this technologies into, they can easily, seamlessly talk to each other, right? Which is really, really important. Interoperability is the cornerstone of standard settings organizations, especially when it comes to telecom. If you look at the structure of standard settings organizations, we have international standard settings organizations, right? Like ITU, ISO, ICE, right? We have international organizations, and then we have national organizations like ANSI, Indian Bureau of Indian Standards, similarly so many other, right? Then we have standard settings organizations which work on private partnership, public-private partnership model. And public-private partnership model, just to give you an example, especially in the telecom domain, we have IEEE standards, we have cellular standards. And when it comes to cellular standards, we have 3GPP partnership program, which develops standards for cellular communication, like the standards like 2G, 3G, 4G, and the existing or the current 5G and the upcoming 6G, 7G, and whatever it is, right? So 3GPP, third generation partnership program, is an organization which develops standards, cellular standards for, or I should say technical specifications, right? That is a more appropriate and accurate description of what 3GPP does. It develops technical specifications and solutions for cellular interoperability or cellular standards, and that is standardized or adopted by 3GPP partner organizations like ETSI, for example. ETSI, European Telecom Standards Institute, right? And 3GPP partner organizations are 8 as on today, and fortunately we have an Indian standard settings organization which is also a member of 3GPP, and the Indian standard settings organization which is a member of 3GPP is known as TSDSI, Telecom Standards Development Society of India, TSDSI. Okay, so likewise we have IEEE which sets standards for wireless communication on wireless fidelity. For example, IEEE 802.11, the suite of all those technical specifications and standards fall into wireless standards, right? Wireless fidelity standards. So just to give you an example, the IEEE set standards for example, if you have a router at your home or your college or your workplace, that routers operate on IEEE standards, which is wireless standards, and the cellular standards are mainly applicable in smartphones, right? And of course, it is coming to laptops also. So it is cellular standards mostly operate here in this device, right? Is it clear? I'll pause here and see if there are any comments so far. Okay, I hear none. So today I'll focus because of the paucity of time. I'll focus on standard settings organizations which operate on public and private partnership, right? So if you look at public and private partnership, for example, HC is one of the standard settings organizations, and when you talk about HC or TSDSI or other organizations which work on public private partnership model, this is what happens. Private organizations come together to form a standard, right? It could be academicians, it could be academics, it could be individuals, it could be organizations, right? And these organizations can be competitors to each other. For example, I would say if it is if it is 5G standard settings, right? In that meeting, you can find Intel, you can find Qualcomm, you can find Apple, you can find Philips. I don't know whether Philips is in that space or not, but just to mention, right? So there are companies like this, and at least if you look at the first 3 companies that I mentioned, some of them could be competitors as well. Now, all these companies come together and they want to find a solution to a given standard problem, right? They want to find a solution to a given standard problem. And in case of 5G, I'm making it very specific so that it is easily understandable. In case of 5G, ITU, International Telecommunication Union, would set a specification. Okay, this is what 5G looks to me, or this is what 5G should look like, right? It will give a standard set of specifications. And 3GPP will take that specification, right? Goal, for example, which is set by ITU, and 3GPP will invite all the members and say, okay, ITU has set a goal and this is what the goal looks like. The bandwidth for 5G should be 10 Gbps, for example, 20 Gbps, for example, right? The power level should be at this particular level, right? So it will put this goal on the table, and all these member companies who are participating, they would like to come up with their own solutions, right? They come up with their own solutions. When they come up with their own solutions, they have groups, they have group of people, they have business units within their organizations who would be working on this specifications to meet these specifications or the goal provided by ITU, and which is set in motion by 3GPP. So they would come back and say, okay, here is coexistence between licensed spectrum and unlicensed spectrum, and this is my solution, right? Company 1 would come up with its solution. Company 2 also would come up with its solution. Company 3 will also come up with its solution. So let us say, for ease of understanding, there are 10 solutions provided by 10 different companies, right? S1 to S10. After deliberation, and we can assume that these deliberations are held in a very congenial environment, right? And also whatever is accepted to become the standard or to become the solution for the given problem statement or a part of the problem statement will become part of the standards. For example, let us say the solution brought in by company 5, which is S5, is selected as the standard, right? Is selected as a winning solution. S5 is the winning solution among S1 to S10, right? What would happen to S1 to S4 and S6 to S10? They would not have acceptability in the marketplace, irrespective of the merit of the solution. For example, S7 can be a much better solution than S5, but S5 for whatever reasons is chosen as the winning solution, right? S5 is chosen as the winning solution. So irrespective of how meritorious it is as compared to other solutions, it is still the solution, the winning solution. So when S5 is selected, or when S5 is voted to become the winning solution, all other solutions from S1 to S4 and S6 to S10, right, will naturally die, because interoperability is the cornerstone of standard settings organizations, especially in telecom domain. Even though S7 is a fantastic solution as compared to S5, it will not find a marketplace, right? It will not find a marketplace. So those which are not part of, or which would not become winning solution, will slowly die down, right? And S5, by the nature of its selection, right, out of 10 solutions, I have S5, which is selected by a standard settings organization, and whoever wants to implement or comply with the standard, they have to implement this solution S5, would bring in certain characteristics to this S5, right? And if this solution has, of course, the company 5 which brought in or which proposed the solution S5 would have protected it with patent applications or granted patents, right? So any patent which is essential to practice this technology, if you are practicing S5, then it means that you are practicing the patented invention, right? That is where the term comes, standard essential patents. A patent which is essential to practice a part of the standard is a standard essential patent, right? So SCP is a technology covering the winning solution. That you need to keep it in mind. And the second important point that you need to keep it in mind is all other solutions, irrespective of their merit, becomes non-feasible over a period of time, right? They become non-feasible over a period of time. There is no demand for these technologies because this is the winning technology which becomes part of the interoperable standards. And when this S5 becomes a part of interoperable standards, the remaining solutions are not standard solutions, right? So they would naturally become much less valuable as compared to S5. And if you look at this and compare it with conventional patents, which are non-standard essential patents, there is one major difference I would like to bring up. In case of SCP, S5 is selected as the winning technology, and everybody who wants to be compliant with the standard has to implement the solution, right? Otherwise, it might not become a standard solution or standards-based solution. In contrast to this, there is a technology, there is a technical solution which is not part of a standard. The inventor would go get a patent on this, right? Inventor would go get a patent on this, let us say, and let us call this patent as conventional patent, which is a non-standard essential patent. If anybody has to come up with a solution for a similar problem, if anybody other than this particular inventor, if they have to come up with a solution to a similar problem, they are free to do so. And the market dynamics would operate. And if this first person who got a patent on a particular invention, let us say A1, is better than the other person who got a patent and implemented a solution which is A2. If A2 is better than A1, A2 will win in the marketplace. If A1 is better than A2, A1 will win in the marketplace. But that competition in the marketplace and the ability to decide in the marketplace is substantially taken away in case of a standard essential patent. That is one of the biggest differences. If I don't license, if I am the SCP holder and if I don't license it to you, of course, the licensing standards are there. We will talk about the licensing standards. But if I don't agree to license it to you after putting the solution into a standard, then you as an implementer, you don't have a choice. You might come up with 100 much better solutions, but they are not feasible in the marketplace because it is standards, right? So irrespective of your ability to come up with parallel solutions or alternate solutions, your solution will not have that much value in the marketplace as a standard essential patent based solution because it is locked into the standard, right? This is one major difference between standard essential patents and patents. There is no difference in the standards, or there is no difference in the criteria that is applied to the examination of these patents. Patent office and the examination departments within the patent offices do not distinguish patents, a conventional patent and a standard essential patent. They don't distinguish, right? They apply the same criteria for patentability, which is NUN, novelty, utility, and non-obviousness, right? Irrespective of whether it is a standard essential patent or a non-standard essential patent, and none is definitely applied and a patent is granted. And by the sheer nature of this invention getting into a standard and becoming part of the standard essential standards, the nature of the dynamics of how it is used and its implications do change, right? So from grant perspective, from the examination process perspective, there is no change. But because of the fact that a particular patent is included into a standard, the nature and the dynamics and how this is viewed changes. I want to pause here and see if you have any questions for me. Any questions so far? Are these basic things clear? Hello? I know post-lunch sessions are always tough. Hello? Can you hear me? Hello? Can you hear me?
Yes.
Okay.
Yes, sir, you're audible.
If I'm talking to you, if I ask any questions, please do respond, at least one, so that I know that I'm being heard and I'm still in this.
No.
Yeah. Okay.
You're all there.
Okay. Got it. Thank you so much. So these are the basic foundational blocks. As per my understanding, these are the basic foundational blocks. We talked about standard settings organizations. We talked about different types of standard settings organizations. We talked about what an SCP is and what is the nature of SCP and the process in which the SCPs are chosen. And we also contrasted it with the conventional patents. Now let's look at the nature of standard essential patents itself, right? Since it is included into a standard, it gets a particular market power, or it gets a dominant power, right? Because if it were to be my conventional patent, there would be, let us say, 5 people or 5 companies who would be interested in getting patent licenses from me. But because my patent is part of the standard essential patent pool, there could be 100 implementers who would want to implement the solution, and they may come to you for license, right? Come to you seeking license. It is very intuitive. It is very intuitive in this very materialistic world to think of it as, okay, once my patent becomes a standard essential patent, once my patent becomes a standard essential patent, then I have enormous power. And when you have enormous power, you know the standard saying, right? Power corrupts, right? There is always a possibility that you could dictate your own licensing terms, including the royalties, right? You could dictate your own licensing terms to the standard essential patent implementers, right? And this, the magnitude or the amount of licensing royalties that you're asking might be too high, right? If you look at the basis of standard settings organizations, the advantage of standard settings organizations is it provides a fundamental technology or fundamental foundational blocks based on which people can innovate quickly, right? And the technology disseminates broadly. That's one of the biggest advantages of standard settings organizations. So people don't have to reinvent their the scope for parallel inventions, right? Duplication of inventions, duplication of creativity is minimized to a particular extent. So that is one of the goals of standard settings organizations. And consumer welfareism is one of the main goals of standard settings organizations. But if the patent royalties are too high, all these objectives of standard settings organizations are defeated, right? If the patent royalties are too high, since it is locked in, people don't have choices. So the implementers have to pay this royalty to standard essential patent holders, right? And what would the standard essential patent implementers do with this particular royalty? If I have paid 25 rupees royalty to you, who is a standard essential patent holder, then I have to pass on this royalties, higher royalties, to my consumers. There is no other way that I can get back my money, get back my investment, right? So that defeats consumer welfareism. And because of high levels of royalty, the actual intent of standards can get diluted. So standard settings organizations thought about it. Standard settings organizations started realizing that there could be issues with standard essential patents and the behavior of the companies, right? Or behavior of the members of the standard essential patents. There are several examples which have gone to the courts, the apex courts of the countries, right, wherein the problems are stated. There are problems regarding SCPs and the behavior of the members of the standard essential standard settings organizations, right? So some of the standard settings organizations, they said, okay, we will come up with some solution, right? And this solution should at least minimize, or it should become a deterrent to the members of the standard settings organizations not to go down the path which could be problematic. And they said, okay, we will come up with a principle known as FRAND, F-R-A-N-D, right? FRAND, F-R-A-N-D is the acronym that they gave, and F stands for fairness, R for reasonable royalties, and ND stands for non-discriminatory, right? ND stands for non-discriminatory. What is fairness? There is no definition of what a FRAND is, and the definitions are decided, or the meaning to the definition or the meaning to this particular principle of FRAND is given by the courts on a case-to-case basis based on the facts of the case, right? As on today, that is where we stand. And fairness stands for, F stands for fairness, reasonable, and non-discriminatory. Just to give you an example to understand fairness, because I did spend a lot of time on this particular topic, right? I did spend a lot of time on this particular topic, researching and understanding the basic concepts of this topic. My understanding is this: fairness is if I am a CP holder, if anybody seeks a license from me, If anybody seeks a license from me, then I should not be saying no. I should treat everybody equally. And irrespective of whether it is a handset manufacturer or a chip manufacturer or whoever it is, I should treat them equally. And anybody who walks into my doors seeking license for this standard essential patents should be granted a license, right? First thing is say yes. Yes, I am ready to grant a license. Now let us talk about royalties, right? Reasonable royalties. When you talk about reasonable royalties, one of the major things is there is an intrinsic value to the patent, right? Let us call the intrinsic value to the patent as X, right? You came up with an invention, the value of the invention is X, let us say. And now this patent is included into a standard, and because that it is included into a standard, the applicability, the demand for your invention increases widely, right? As I said earlier, there are more than 100 to 1000 implementers who want to seek license from you, and the intrinsic value of your patent is X. Because it is included into a standard, you should not be seeking royalty of X plus Y plus Z, right? Y plus Z in this particular case is royalty which is not reasonable. In fact, because you included your patents into a standard and you got access to a wide range of or wide variety of standard implementers, a school of thought says, in fact, your licensing royalty should be less than what the intrinsic value of the patent is, or probably at least the same as the intrinsic value of patents. But if your licensing royalties are ballooned up, right, just because of the fact that your technology is included into a standards, then that is unreasonable according to some, right? What happens, right? If I say the value of my patent is X, intrinsic value of my patent is X, and I have included it into a standards, and just because of that it becomes X plus Y plus Z, then you are getting double benefits, right? First thing is, by including it into a standard, instead of 5 people coming to you for seeking license, you now have 1000 people coming to you for seeking licenses. So your licensing, the pool from which you are getting licenses, the number of people from which you are getting licenses has increased on one hand, and on the other hand, you are saying because it is included into the standard, the royalty that I'm expecting is more, then you have double advantage, right? So that double advantage should not come into play. That is what is one of the thoughts or one of the principles to say that reasonable royalties should be very close to the intrinsic value of the patent, and it should not include the price, or it should not include the royalties because it is included into a standard. That component should be taken out of the calculations or the equations used to calculate the royalties. So that is reasonable royalty. Okay. Non-discriminatory, the third component is non-discriminatory, which simply means this. Okay, let us say I have a standard essential patent, and 5 people or 4 people come into my doors, walk through my doors and ask for royalties. I would say, okay, A, B, C, and D. For A, for the same standard essential patent, I will charge you 50 paise, right? For B, I'll charge you 75 paise. For C, I'll charge you 1 rupee. For D, I'll charge you 1.5 rupees. Now, if they are including the standard essential patent into the same handset, for example, this handset, let us say, right? If they are including it into the same handset, A would sell it at 100 rupees, which includes 50 paise, right? Of the licensing royalties that he gave to me, he paid me. B, manufacturing a very similar product, right, has to sell it at 100 rupees 25 paise because he has paid 75 paise as the royalty. And C, who has got a royalty, licensing royalties at 1 rupee, has to sell it at 101 rupees and D, who manufactures a very similar product, should sell it at 101 rupee 25 paisa. So if you are a consumer and if you go to the market and look at this particular product from A, B, C, and D, which is substantially similar, right? Which is substantially similar from a feature standpoint, why would you pay 101 rupee 25 paisa as compared to 100 rupees which is offered by A? So as a SCP, what it translates into is, if I discriminate the licensees based on the royalties, right, then I am sitting in my boardroom and deciding who the winner should be in the marketplace. And I should not be doing it, right? I should grant a license to my patent, collect royalties, and innovate. I am not the one who decides who should win in the marketplace. And once you are discriminatory, if you follow discriminatory practices, you are sitting here and deciding that A should be the winner because you licensed it out at 50 paise as compared to D, who was licensed at 1 rupee 25 paise. So there should not be discrimination whatsoever, right? There should not be discrimination in the royalties and the terms of the contract, licensing contract among the similarly placed license seekers, right? Licensees. So this is the concept of FRAND. So if you take back these principles and apply it to Indian companies, it is the same. These are the same principles throughout the world. These are the same principles throughout the world. Wherever you go, FRAND means the same thing. Understanding of FRAND is almost the same thing, even though it is not defined. And these terms are what should I say, given a meaning based on the facts of this case in the courts. All this time I talked about the what should I say, things that were not so favorable to or they were more favorable to standard essential patent implementers, standards implementers, right? To bring the balance, I also talk about some of the things that that can be misused by the SCP implementers itself, right? If I am a SCP holder, I would have pumped in a lot of money for invention, right? R&D budget would be billions of dollars, billions of euros, right? Or it could be 10,000 rupees. I put in 10,000 rupees. I came up with an invention. Now I included it into a standard. It became a standard essential patent. Now there are 100 implementers who are implementing my SCPs. I go to them and tell them, okay, you're implementing a 4G standard, and 4G has a standard essential patent owned by me, and this standard essential patent is covering a technology which is essential part of the standards, right? Which is essential part of the standards, which means that there is a very, very high probability that you might be implementing the solution that I brought to the table and I have a patent on it. I want to negotiate with you, right? And the SCP implementer would not respond for 6 months, right? He would not even respond for 6 months. He or she, let us say, right? I invested the money. I came up with the solution. I took part in the standards. I included my invention into the standards, and I made a promise to the standard settings organization that I am ready to license my patent on a FRAND basis, based on FRAND principles. But the implementer, at the end of the day, is not even responding to my emails, responding to my communication, which is very frustrating. I understand that. Excuse me. And after multiple attempts, they would come back and say, okay, you're asking me 100 rupees as the royalty, but I can give you only 2 rupees, right? I can give you only 2 rupees. The offer is 2 rupees. This offer need not be fair at all, or this offer need not be reasonable. It is well below the reasonable standards, right? So those kind of tactics are also used by some of the SEP implementers. Those kind of tactics are also being used by the SEP implementers. So courts around the world are grappling with those issues, and they are coming up with orders, court orders and judgments which would bring a balance. For a very, very long time, right? For a very long time, the pendulum swung in the favor of SEP holders, right? And SEP implementers suffered. Now the pendulum is shifting back to the center. Of course, it will definitely come and stand at the center, because once it comes and stands at the center, it means that all the problems with this particular field is solved. That might not happen, but the pendulum keeps swinging from one direction to the other. And one thing that I can say is, if you look at the court cases and how courts have approached this, the pendulum swinging has come down. What do we call this? Swing from one end to the other, or probably from one position on the left to the left to another position of the right. That swing is coming down, which means that we are moving towards a balanced, much more balanced position, wherein the implementers, SEP implementers and the SEP holders are fairly benefited. So it is a fair play for both of them. With that, I would stop here. And whatever I spoke today is mostly principles and theory with few examples, right? When I get an opportunity to talk to you next time, I would definitely talk about court cases and talk about each of the court cases and what happened in each of these court cases. Thank you very much. If there are one or two questions, I would be happy to answer them.
Thank you for that talk, sir. It really opened our eyes to the world of FRAND and SCPs. So there are a couple of questions in the chat box, so I'll just be collating some of them and asking you your views. So Mr. Rohit asks, what are your views on precision and bias of essentiality checks and rates of declared SCPs?
Oh, okay. Precision, when you say precision, probably you are referring to accuracy of a patent which is included as a standard essential patent, and whether it is really a standard essential patent or not, right? So today there are no checks done. If you look at ETSI, right, European Telecom Standards Institute, if I go declare as a member, if I go declare a patent to the standard essential, to the standard settings body, which is ETSI in this particular case, as a standard, right, or as what should I say, as an invention and a patent reading on a standard, then I would be asked to upload my upload the details of this patent into a database. And if you are asking me if somebody would go into that database and check and see whether the claims in this particular patent application or claims in a granted patent is really reading on a patent, no, that check does not happen. That check happens during a litigation, and if some patents are included into the litigation, become part of the litigation, then that rigor is brought to those patents. There are thousands, there are thousands and thousands and thousands of patents declared to the standards. Who would do the accuracy, right? Accuracy check or a precision check, whether it is really a standard essential patent or not, is not, no. SSOs do not do the check because they don't have that bandwidth and what should I say? They don't have the bandwidth. They don't have the money to do all this, right? So if a portion of that standard essential patent pool, if 1 or 2 or 3 or 10 patents become part of the litigation, then it is the responsibility of the parties to establish the validity and essentiality of the patent. Okay.
So then the burden of proof is essentially shifted on the patent holder in that case. Is that correct, sir?
Yes.
Got it. Thank you so much, sir. So there is also one question by Mr. Rajendra Singh, who asks that is it not necessary that SCPs are provided in the public domain so that all concerned can use them without the possibility of infringement or need for license?
So you're asking for a free meal, which does not happen in the in reality, right? I invested 10,000 rupees. I burnt the midnight oil. I came up with the invention. Why should I give it for free? Why should I put it into the public domain and give it to you for free? Just because it is a standard essential patent? I would not include my patent into standards at all. If you are proposing that, I will not include it into standards at all. So over a period of time, and I could say this, the fall is like this, sharp. Standards and its relevance drops down, and at the end of the day, it is the consumer who suffers. It's always a balance, right? There is no free lunch.
Understood, sir.
I'm not talking because I come from the industry or work from the industry. Even if I don't work for an industry, even if I'm not part of the industry, I would still say the same thing. If I have put in my hard efforts, I need to be rewarded. Otherwise, there is no motivation. As it is, the inventor pool is very, very less. Look at the number of inventors in this world, right? If you look at the number of inventors just by the number of patent applications filed in the patent office, right? This year it was 56 or 57,000. Even if you assume that there are 5 inventors in each of these patent applications, it is 2,500, 50,000 into 5, right? 2,50,000 or 3 lakh inventors per year. 3 lakh compared to 1.2 billion. So don't hold them by the throat and stifle them.
So, if you don't mind, we also have 2 more very interesting questions. So, can I put them to you?
Yeah.
Yes. Okay. So, Sayyad asks that if a bundle of SEP is owned by an entity and they are insistent on only licensing that bundle together, can the potential licensor probably force their hand on getting only a particular SEP? Or if he continues with the question by saying that if the entity which owns the SCP does not want to sell it individually but only in a bundle, would that be an infringement of the FRAND standard?
Okay, great question. These are some of the things, some of the real issues, and this particular question would fall under misuse or abuse of standard essential patents, right? Since I did not have the time today, I could not cover it. SCP holder can come up with, okay, hey, SCP implementer, you are saying that you want license to one standard essential patent, but actually, see, if you take license for this 10 standard essential patents, it would benefit you because you are agreeing to get license for this 10 standard essential patents, right? Because you are building a mobile phone which is compliant to 5G standards. I, as a SCP holder, think that these 10 standard essential patents that I am holding is really important to you. You would need this. That is still fair, right? SCP implementer can look at these 10 patents and see, okay, oh, all this fall into the essential portion of 5G standards. So let me take. But a more, what should I say, amplified problem is this. I have 10 SCPs, right? I bundle this with 20 non-SCPs and I make it a condition. If you want license for these 10 SCPs, which are essential for implementing 5G, you should also take license for this 20 non-SCPs, right? I don't want, as an SCP implementer, I don't want license for this 20 non-SCPs. But because you are a SCP holder, you are in a dominant position. You are arm twisting me to get license for this 20 non-SCPs. That is wrong. That is not FRAND, right? If it is FRAND, if all these 10 patents are FRAND SCPs, then we can still look at it, right? Whether they are essential, whether there is a requirement or not. There could be good intent from the SCP holder saying that, okay, take license for this 10 SCPs, you will need it. We can negotiate because you are taking 10, I can give it to you for lesser price. That is still I would say, okay, you can sit and negotiate. But in bundling it with non-SCPs, which I really don't want, is the real problem. There are real issues like that. There are real issues like that, right?
Understood, sir. Sir, Mr. Pankaj asks on your take on open standards in general for India and with respect to certain domains such as the cellular internet space and the convergence of such open standards with these spaces.
What do you mean open standards? It goes back to the second question, right? Just because, are you saying that, okay, there should be open standards, and once I include my patent into open standard, I should not be charging royalty? If that is the intent of the question, then I have already answered the question, right?
Okay,
3GPP.
so Mr. Rajendra Singh has
Yeah.
been insisting on this question. So why are the chargers of a mobile handset so mutually different? What are the standards as you had narrated in the session earlier, sir?
Oh, okay. I was talking about reasonable royalties for SCPs, right? That does not stop you from charging differentially for the handset. iPhone costs you one lakh rupee, whereas Vivo costs you, with a similar set of features, Vivo costs you 50,000 rupees. That is not just SCPs, right? It is beyond SCPs. It depends on so many other factors, right? It depends on so many other factors. It depends on the features that are included in the phone. It depends on the sensitivity of the screen. It depends on whom you are buying the chip, whether you bought it from Qualcomm or MediaTek or whoever it is, right? And how did your logistics work? Did you get it manufactured in China, or did you get it manufactured in South Korea, or did you get it manufactured in US? What is the tax for this particular product in a particular country? There are several other things. SCPs is just one tiny small part, and we are talking about that tiny small part, which cannot be applied to the entire device, the price of the entire device, right? That's why it is not normalized.
Got it, sir. Thank you, sir. So just one last question. I think this also relates to the logistics rather than the doctrinal aspect of FRAND and SCPs. Is that when there is a difference between the buying and the selling powers? So I guess, yes, Mr. Ashok Kumar asks that the purchasing power of the SCP implementer in a developing country may be low, and the purchasing or the selling power of the SCP holder who may be from a developed country may be very high. So how are such situations generally handled in the overall scheme of things?
Okay. See, the issue with FRAND is FRAND and especially royalties is, especially when it comes to SCPs, it is beyond the borders, right? What I mean by that is, if I grant you a royalty based on your financial position and your registered office being in a particular country, let us say India, right? I charge you a royalty of 50 paise. Okay, just to put a number. If I go to the developing world, let us say Switzerland, and if there is a manufacturer who wants a license for this, I cannot give it to him for 50 paise because he is well placed. And if I give it to him for 1 rupee, that implementer would say, oh, for the same standard essential patent in India, you charge 50 paise, and why are you charging 1 rupee for me here? Just because I am in Switzerland? There is no way you can justify, right? There is no way you can justify that. So at least today, throughout the world, the royalty rates are, SCP holders do not want to make a variation on the royalty rates based on the country and based on who the licensee is, right? So they want to keep it at the same level.
Thank you so much, sir. Sir, are there any concluding thoughts that you would like to share with us today?
It was a great session, great interaction, loved talking to you. Thank you very much, NALSAR Chair, IPR Chair, Dr. Anindya Sarkar, sir, who is a great friend and a guide to me. Thank you so much for the opportunity. And I see a lot of friends like Shubdeep Sarkar, Biju Nair, Chitra on this call. Thank you so much for a very patient hearing. Thanks a ton.
Thank you so much, sir. We're looking forward to having you here again with us.
Thank you.
Thank you.
Same here. Thank you very much.